Our speaker today, Edward Whelan, is a distinguished senior fellow of the Ethics and Public Policy Center and holds EPPC's Antonin Scalia Chair in Constitutional Studies. He was previously the president of EPPC, and he directs their program on the Constitution, the courts, and the culture. From just before the terrorist attacks on September 11th, 2001 until joining EPPC in 2004, Mr. Whelan was the Principal Deputy Assistant Attorney General for the Office of Legal Counsel in the U.S. Department of Justice. He previously served on Capitol Hill as General Counsel to the U.S. Senate Committee on the Judiciary. Mr. Whelan was a law clerk to Justice Antonin Scalia on the U.S. Supreme Court and Judge J. Clifford Wallace on the U.S. Court of Appeals for the Ninth Circuit. Please join me in welcoming Mr. Whelan.
Thanks very much, Connor. Thanks to all of you for being here. I'm delighted to be at UVA. I think it's one of the outstanding law schools in the country, and pleased to be here talking with one of your colleagues that the atmosphere of free exchange of ideas remains vibrant here. The triumph of the conservative legal movement, question mark. It's a big topic, a lot to say, and I look forward to hearing your thoughts. Let me begin as a preface by explaining what I mean by the term conservative legal movement. I'm really drawing in part on a wonderful book that a political scientist by the name of Stephen Tellis has written called The Rise of the Conservative Legal Movement. I think we need to understand the conservative legal movement not as a monolith, not as a single organization, but as a loose coalition of organizations that mobilized to challenge the dominant liberal legal network and to promote conservative ideas and results. It really started, I think, first in the late 60s or early 70s. Developed conservative public interest groups, the law and economics movement, and of course in the early 1980s, the Federal Society. It involves people as disparate as those who are strongly pro-life, pro-guns, libertarians, religious conservatives, advocates of small government, Chamber of Commerce folks, and those interested in national security. And there's a real mix of ideas that's changed and evolved over the years. Judicial restraint, libertarianism, originalism, and textualism. And the composition of the movement itself has changed over the years. I think we've seen, for example, the role of business groups has, I think, declined in the movement. The conservative legal movement plays an important role in the broader conservative political movement. There's lots of room to discuss just what that role is, but I think in many ways it's the intellectual engine of the movement. So I want to make the case both for and against the triumph of the conservative legal movement. So let me start with the pro case. What greater triumph could there be after all these years than the overturning of Roe versus Wade and Dobbs last year, and then this year, the overturning of Bakke and Grutter? These were results that were unimaginable to people decades ago, and some of you are too young to appreciate this. I was a law clerk for Justice Scalia when Planned Parenthood versus Casey was decided. That was the first clear opportunity to overturn Roe. Lots of people thought it was going to happen. We had 3 new Republican justices, well, 4 actually, from Reagan on, and it was thought that we could count on Justice O'Connor and Justice Kennedy and Justice Souter to be strong votes to overturn Roe. Roe, after all, had been ridiculed even by supporters of abortion as incoherent, legally indefensible. So here we had this opportunity, and instead, in a crushing blow for the conservative legal movement, the court, by a vote of 5-4, voted to reaffirm Roe in a joint opinion by Justices O'Connor, Kennedy, and Souter, an opinion that adopted a grandiose conception of the judicial role and bears no trace at all with conservative jurisprudence. I worked for Senator Hatch immediately after my clerkship with Justice Scalia on the Senate Judiciary Committee. I was the lead staffer handling the confirmations of Ruth Bader Ginsburg and Stephen Breyer in 1993 and 1994. Republicans rolled over and played dead on those nominations. There was no fight. Ginsburg was confirmed 96-3, Breyer 87-9. No one wanted to take on the fight over judicial philosophy. If you had told me back then that we would be where we are now, I would not have believed it. I assumed all these years, as I think most folks did, that Roe would never be overturned. I assumed for a long time that even as I worked against it, that it was been difficult to get Republicans to fight judicial confirmation on the grounds of judicial philosophy. But that's what happened, and that's key to the triumph over the decades. So let's look at what's happened here. Again, from Planned Parenthood versus Casey going on. You had the flourishing of the conservative legal movement through organizations like the Federal Society, with the intellectual munitions provided by Justice Scalia and Justice Thomas, particularly, most often in dissents. You had the legal movement coalesce around the twin concepts of originalism and textualism. Different names for basically the same methodology. They were rising to counter different confusions in the constitutional and statutory areas. But they described essentially the same method, interpreting legal provisions according to the meaning they bore when they were adopted. That includes, of course, constitutional amendments and statutory revisions. Over time, I think the common sense appeal of originalism and textualism just trumped the opposition. You could see the intellectual vacuity of liberal legalism. You had the Federal Society promote debates where, as students confronted these ideas, they saw disproportionately how the merit of conservative legal notions. And this, in turn, also was reflected in the change in the judicial confirmation process. You can compare two sets of judicial nominations, I think, to really see this clearly. I've already mentioned Ginsburg and Breyer. Well, 16 years later, you had a situation that was almost on all fours, almost identical. You had a newly elected Democratic president, Barack Obama here rather than Bill Clinton, who had a massive majority in the Senate, and who had the gift of 2 Supreme Court vacancies in his first 2 years in office, who had a keen interest in constitutional law, who had himself taught constitutional law, true of both Clinton and Obama. And you might have thought that, looking back at 93, 94, you'd have overwhelming confirmations of Obama's nominees. But no, instead, Republican senators waged a battle over judicial philosophy. You know, not the perfect battle. These are senators after all. But they tried to engage, and you ended up with more than 30 votes against each nominee. If you had told me in 1993 or 1994 that my boss, Orrin Hatch, would vote against the first Hispanic Supreme Court nominee, I would not have believed it. Toss in that this nominee is a female would have been unimaginable. But the terrain had shifted under him and under other senators, and you had the conservative movement mobilize on judicial nominations. And this happened first, seems like yesterday to me, but I guess looking around, some of you may not really remember this, but this happened first on George W. Bush's judicial nominees. First was lower court nominees when Senate Democrats instituted the filibuster of these nominees, unprecedented partisan tool waged against these nominees. And then against the nominations of Chief Justice Roberts and Samuel Alito in 2005, 2006. Briefly on the filibuster. This is, DC jargon. A lot of you probably understand this, better than I do. But essentially, before you go to a final vote on any matter in the Senate, you need to get cloture, or you need to get all 100 senators to agree that to waive their right to insist on cloture. And the formal cloture rule calls for requires 60 affirmative votes. Now, it had long been understood that that this wouldn't be invoked against judicial nominations, and for years and years, it wasn't. Even in the bitter fight over Justice Thomas's nomination in 1991, if anyone had said that's not a cloture vote, he would have been defeated. People thought this is not a fair tool to use here. But that changed in the George W. Bush administration. And you had big fights over judicial nominations as a result. And you had the conservative political movement, mobilized by the conservative legal movement to fight for these nominees. And again, likewise in support of Roberts and Alito. One of the most important moments, though, happened in 2005. Let me ask you this. How many of you, I don't mean this to be an embarrassing question, can tell me who Harriet Myers is? Okay, I see a few hands. Arguably the most, one of the three most important events in the last 20, 30 years on judicial confirmations was President George W. Bush's nomination of Harriet Myers to be the Supreme Court Justice in 2005. He nominated her to Justice O'Connor's seat immediately after John Roberts had been confirmed, beginning of October, I believe, 2005. And what a shock this was to the conservative legal movement. Harriet Myers, God bless her, she had been George W. Bush's longtime personal lawyer, no judicial experience, unknown to the conservative legal movement. And conservatives rebelled. Said, look, we made the mistake of trusting your father and John Sununu back in 1990 when you nominated David Souter. We're not going to make that mistake again. And I think it's a sign of the real maturity of the conservative legal movement, as well as the mobilization that changing technologies like the internet made possible, that that nomination collapsed very quickly. And Samuel Alito was nominated, confirmed instead. Because the conservative legal movement said, no, we want someone who we can count on to provide intellectual heft, to be not just a vote, but a powerful voice on the court. This sort of justice who could vote, who could write an opinion to overturn Roe versus Wade. The second big episode I'll mention is the Scalia vacancy that arose in 2016. It was quite a shock to me when I got a phone call on that Saturday afternoon in February 2016 informing me that Justice Scalia had died. Almost the first words out of my mouth after just expressing my grief, this was about an hour or two before the news became public, was we have to keep the seat open through the election. Can we do that? I don't know. We have to try. And you had this important blockade that Mitch McConnell led, keeping all the Republican senators in line. And this blockade, I want to emphasize, had been scripted in advance by Senate Democrats. This was exactly what the Judiciary Committee chairman in 1992, a fellow by the name of Joe Biden, said he would do if a Supreme Court vacancy arose that year. This is exactly what Chuck Schumer said to thunderous applause to liberal lawyers in July 2007, more than a year before that presidential election if a vacancy arose then. This is what Obama's White House counsel in an event with me candidly admitted she would have recommended if the situation were reversed, that is, if you had a Republican president with a Democratic majority in the Senate. This was, of course, the first vacancy, I should say, of course, first vacancy since the one that Justice Thomas filled, where you had a president of one party making a nomination to a Senate controlled by the opposite party. And it was the iconic Scalia seat, and it was coming up, granted, 9 months before the election, but the election very much in sight. And so this presented the possibility for keeping that seat open. Donald Trump put out his list, ran on the promise to select someone from the list. That was critical in his election, and we owe Mitch McConnell a great debt for keeping that seat open. The third transformative event, one that will stand out, I think, as historically idiotic, though I think everyone knew at the time, but Democratic senators couldn't help themselves, was the filibuster of the nomination of Neil Gorsuch in the spring of 2017. this was a seat that had been, the Scalia seat that had been left open. Very early, and within the first 10 days of Trump's presidency, he nominated Neil Gorsuch. And there's broad support for Neil Gorsuch from important liberals, highly respected. But the base of the Democratic Party drove Democrats to filibuster Gorsuch. Let me back up a step here because I think it's important to understand this in context. So Democrats launched the filibuster against lower court nominees in 2003. Republicans tried to override the filibuster in 2005. They failed. They don't get the votes. Democrats then have the filibuster. Obama has the filibuster used against his nominees when he's president, and Harry Reid, who could dish it out but couldn't take it, then abolishes the filibuster for lower court nominees in November 2013. He left the filibuster in place for Supreme Court nominees. Now, what principle explains why he would abolish it for lower court nominees as well as executive branch nominees, but not for the Supreme Court? This is a trick question. Anytime there's a question about the Senate that says what principle explains. No. Pro-abortion groups said, don't abolish this for the Supreme Court. We can do that in the middle of the fight if we need to, but if you do this now, you're going to make it easier if he has a Republican president, a Republican-controlled Senate, to get a nominee confirmed who's anti-Roe. Don't let that happen. And even 2 weeks before the 2016 election, Harry Reid, who's going to be leaving the Senate, was crowing that if Republicans dared to filibuster Hillary's Supreme Court nominee, the filibuster would be gone like that. So what happened is the very people, John McCain, God bless him, most prominent among them, who had prevented the Republicans from abolishing the filibuster back in 2005. In 2017, they said, you're giving us no choice. If you are going to filibuster someone like Neil Gorsuch, we're never going to get the seat filled. So you had Republicans unifying to abolish the filibuster for Supreme Court nominees. Without that, there's no way Brett Kavanaugh would have been confirmed. He probably would not have been nominated. And there is no way at all he would have been able to get any conservative justice confirmed in the last few months of the Trump administration. It'd be very easy to use the filibuster to delay, and you would not have the court we have, but for what Senate Democrats did in the spring of 2017. And of course, this then led to the Dobbs overturning, which I think is just a triumph of the conservative movement, again, beyond what any of us could have hoped for not very long ago. You also, as I mentioned, have the ruling this June in the Harvard and UNC cases. You've had the court recognizing that the Lemon test in the Establishment Clause context has been overturned. And you have a general composition of the court with, you can debate the different justices, but 6 justices who are up for grabs at the very least, gettable on the broad range of conservative legal issues, and 4 of the 5 youngest justices are conservatives. So yes, has there been a triumph of the conservative legal movement? Absolutely. Now for the contrary case. Okay, I concede you make some good points, but look, the broad legal terrain is defined by decades of liberal judicial activism. We have not begun to alter that. Warren Court precedents, post-New Deal court precedents are all over the place. There's a staying power of these bad precedents. It seems unimaginable that we're going to begin to make much progress in overturning those. What's more, yes, there have been some important victories, but they're incomplete. And whether they'll be complete or not, who knows? Take the Harvard and UNC racial preference cases. those cases were decided on constitutional equal protection grounds. The mistaken ruling of the court on the Title VI statutory grounds persists. What that means, among other things, is we don't know how broadly this principle of non-discrimination will extend to other areas where racial preferences have been prominent and have shaped so much of the landscape, as in employment, for example. What's more, there have been some big losses. The Bostock case is the most prominent in recent years, arguably. That, of course, is before Amy Coney Barrett came on the court. But it was 6-3, and one would have to be something of a cynic to say that the result would be different if she had been on the court. But I'll say I think the result would have been different if she had been on the court. As I think the chief spoke there is very difficult to understand on the grounds of his principles. You talk about triumph, but look at these divisions among conservative justices. They're often shooting at each other. It's not really clear in any particular matter whether they're going to be together or not. There's a whole debate over originalism and textualism. Bostock, illustrates that some justices can take textualism astray. There are divisions within the conservative legal movement. So we talk about a triumph of the conservative legal movement. What we're seeing is a movement that has all sorts of schisms. Take, for example, the question of free speech and big tech power, a whole host of other issues. More than that, the battle has to be broader than the Supreme Court. The conservative legal movement needs to be about more than conservative Supreme Court justices. It needs to be, first of all, about the broader judiciary, the lower federal courts and the state courts, and what we see happening right now in the lower federal courts, is President Biden is making a historic number of appointments to these lower courts and undoing, thanks to Donald Trump, a lot of what Donald Trump had accomplished. Had Republicans retained control of the Senate, had we not thrown away the 2 Georgia seats in the runoffs, a day before the January 6th atrocity, things would be very different. Beyond that, we have a conservative legal movement that's too focused on the courts. What about legislatures? What are we doing to get good laws enacted? Are we really being as effective as we ought to be throughout the country? And then beyond that, of course, the conservative legal movement can do only so much. We have a culture around us that maybe you're more optimistic than I am, but if you had told me again decades ago that would have folks celebrating the decapitation of babies in Israel. I visited 10 years ago the very kibbutz where these atrocities occurred, and it's just so horrible what happened there, and to see people somehow, also very bright people, just having so lost their sense of morality that they're resorting to victimhood and power politics to excuse or justify this is appalling. Okay, a third point, that's somewhere in the middle. Yes, there's been big triumphs. No, they're obviously not complete, and you have to have asterisks next to them. But beyond that, things are vulnerable. You have a court that has 3 liberal justices, but it's easy to see just natural turnover how those 3 could become 5 in the not too distant future. Justice Thomas is 75 years old. Justice Alito is 73. If Joe Biden were able to replace just one of them, then the Chief Justice would become the median justice again. What would that mean for many of these issues? Who knows? How long will this conservative majority endure? So much depends on what happens in 2024 and coming elections. Are Republicans going to win the presidency, or will Democrats? Will Republicans win control of the Senate or not? Um, and then you also have the threat of court packing. Now, it's been easy so far to dismiss the threat, as I've often done, and I still think it's a bit of a long shot. And I also think that if you start doing the court packing, you go from 9 to 15, then next thing you know, it'll be 27, 81. I think India has a Supreme Court of nearly 100 members, so we would have that before we knew it. But those dangers are there. It is the case, I think, that the conservative movement, legal movement, is divided. Now, there have always been some divisions, and I think judicial confirmations have served to unify the movement. The battle against Roe also did, though frankly, I think a lot of people were able to, it's easy to criticize Roe when you thought it would never be overturned. But we see big challenges on the administrative law front. Again, an area where I think the conservative movement has done a bit of a 180, and we'll see how stable the new position is. One big target for the conservative legal movement is an opinion that Justice Scalia wrote, Employment Division versus Smith, on the free exercise clause. So this also highlights that what is now, well, to be fair, religious conservatives condemned Smith when it came out, but I think it's also true that what the conservative legal movement sees its priorities in one decade, it may well change the next decade. I'll finish my remarks here and go to your question by just saying my own view, having argued different sides of this, is that there have been important triumphs, again, that one could hardly have imagined. There has been no decisive general triumph. I think it's the nature of our politics that there probably will never be a decisive general triumph. That's, I think, part of living in a pluralistic, liberal democracy. No triumph is permanent or complete. But for those of us in the conservative legal movement, there is a lot to celebrate, but there's no occasion to be complacent. Thank you. Happy to talk with you about any aspect of this. Very ready to go deeper into some of the points that I made, but please welcome your questions, comments, disagreements, challenges, softballs. Yes.
What do you think about, and I think this is true, it seems like conservative justices, conservative judges disagree with each other or have more nuanced views on certain topics than necessarily like liberal judges. I don't want to paint a broad brush, but I think a lot of people agree that they are better at voting in a block when it comes to important issues. So do you think that's a virtue of the conservative legal movement? Because I think that is what attracts a lot of people, is like the intellectual vigor, like you had said. So I think it's hard to say that it's a failure if we do have judges disagreeing with each other in a constructive way. So.
No, I think that's a great point. Look, it's not easy to apply originalism or textualism, and it's not surprising that there'll be difficult cases where justices will weigh the relevant materials, assess them differently. So I think it is a tribute to conservative legal principles that justices will sometimes find themselves in different places. By contrast, if you take living constitutionalism or whatever moniker it now uses, it seems to discredit one after another, so it's hard to know. Justice Ginsburg would say, "I don't look at the weather of the day; I look at the climate of the ages." What does that mean? One reason why originalism and textualism have won, as Justice Scalia sometimes put it, is there's no competition. What's the alternative? And what has the left come up with that's coherent and in any sense determinate? So yes, when you look at the three liberal justices on the court, tell me one significant matter in which they have been in different places, and where one of them, say, has provided a decisive vote. Go back to the 414 court we had for so many years. okay, Justice Kennedy often went with the liberals. Was there a single time you can come up with where you had one of the liberals go with the conservatives, for a 5-4 ruling? I can't think of one. Perhaps I'm forgetting something, but I don't think there were any. So, and look, the left says that law is just disguised politics, so it's a surprise that its judging would be as core political. So yes, I think it's a tribute to the legal conservative movement that justices, judges try to apply these difficult methodologies and sometimes end up in different places. It's a craft, and craft can be performed well or performed poorly. But that doesn't discredit the craft. It just speaks to the relative ability of the different craftsmen and craftswomen. Yes, sir.
Hi, sir. I was wondering if you could talk a little bit more about how, in your view, Justice Gorsuch misapplied textualism in Bostock, especially in relation to Title VII.
Well, that's a big question. I'm not sure I'm going to be able to do it adequately here. But let me try. And I've written a little bit about this, so I guess I'd encourage you to, if you want a better answer than I'm probably able to provide here, to look at what I've written before. I think Justice Gorsuch's view, first of all, would have difficulty explaining how we've been able to have men's and women's bathrooms and all sorts of other things that distinguish on the basis of sex without being unlawful discrimination. Beyond that, and I think Justice Alito did a good job of pointing this out in his dissent. I think his, whatever you call it, his function test, saying that somehow anytime there's discrimination on the basis of gender identity, there's also discrimination on the basis of sex. I think that's mixing different things. I don't think it works. I don't think that it's plausible, for the reasons that Justice Alito spells out, that the original meaning of Title VII, as the enactors understood it, would have protected these things. That doesn't speak to the policy question, whether there should be protections. And of course, there were big debates going on over modifying this, and suddenly, those debates are over because of this ruling. So no, I think it's a very troubling and troublesome ruling. It's causing problems in all sorts of other areas. We'll see whether it can be confined or whether it spreads. Yes.
You mentioned that originalism is central to the conservative legal movement. What do you think would be the originalist interpretation of the Senate's power to give advice and consent on a presidential Supreme Court nominee? Does that include the tit for tat reasoning that you just described? Or
you bet. Originalism would say that the Constitution confers plenary power on the Senate to make whatever rules it sees fit. It would say, as everyone knew before somehow they forgot in 2016, that the Senate can stop all sorts of nominations just by inaction. And the notion that there's some sort of constitutional duty to vote on a Supreme Court nominee is belied by all of American history. First, it's the same appointments clause that applies to Supreme Court nominees as to every other judicial nominee. The very folks who concocted this argument in 2016 supported the filibuster of Sam Alito in 2006, trying to keep him from having an up or down vote. So yeah, I think from an originalist perspective, this is very easy. The Constitution does not speak to the political question of how the Senate carries out its confirmation powers. There's plenty of room to argue over how it ought to do and to criticize it. But I think it is clear that the Senate has plenary power to act or not act on any nomination. The whole thing about hearings, of course, there's nothing in the Constitution about hearings. That's an exercise of the Senate's rulemaking power. You can look to, I don't know if it's in the thousands, it's certainly probably must be in the thousands by now, the number of nominations that have been stopped by simple inaction. So I think that's one of the easiest questions for originalism. There are some difficult questions, I don't doubt, but it was beyond peculiar to see very bright academics concoct all these kooky claims back in 2016, constitutional claims. Again, politically, you can say, how dare you obstruct this nomination? We should vote on it. Fine, and if you're a cynic, I suppose you can see these constitutional claims as just a part of a political campaign. Maybe people don't really take them seriously. But when I see my former common law professor, Larry Tribe, sign on to this first letter, and then I look and see in his book that he wrote in 1985 to encourage Democrats to stand up to President Reagan's nomination. And he says in that book, he says, of course you can stop by simple inaction. And he cites a case, an instance of a Supreme Court nominee from the 1880s or somewhere back there. So yeah, I respectfully don't think that this is a difficult question for originalists.
Yeah, I guess your answer doesn't really seems more of an extended argument that goes to the tit for tat part. And I was curious more about like the original intent of the drafters or something like an actual originalist argument, not just this is what politicians do and this is what law professors say.
Oh, well, let me be more precise on the text here, which I think does confer that plenary power. They say, first of all, there's a provision, I don't have the particular clause in front of me, that gives each house the authority to make the rules governing its proceedings. And secondly, there's an appointment clause itself that says the president shall nominate and by and with the advice and consent of the Senate shall appoint all these different officials. It says nothing about how the Senate shall conduct that advice and consent role. And everything in American history speaks to the Senate's plenary power to act as it sees fit. So, I mean, there's this weird thing where everything, things that by their nature are purely political, the left tries to treat as though they're legal arguments, and things that by their nature are legal, they try to treat as political arguments. So I just don't see this as a difficult question. But I'd love to hear what's the opposite argument. I mean,
I'm curious more from the perspective of how far this conservative idea will go. So if President Biden is reelected, for example, and one of those seats you mentioned becomes available, would it be within the plenary power of the Senate in the first year of Biden's term to deny that seat?
absolutely it'd be within the plenary power.
And what do you think the implications of that are?
Subject, of course, to all the political pressures on senators. Look, I think if the Senate had, I can't prove this, of course, but I think the Senate had been in Republican hands in 2002. I think Ketanji Brown Jackson would still have been confirmed. And I think the next time you have a situation, again, I'm not going to prove this to you, and you're entitled to be skeptical, but as I pointed out, the very approach that McConnell took in 2016 was exactly what Senate Democrats had been prescribing, and it's what they will prescribe again. Even I think even in a first year. Now, if I were a betting man, I would say that if let's say a Republican president is elected in 2024, and you have a Democratic Senate, it's a weird constellation. It doesn't usually happen, and it's not surprising that almost all instances, well, all instances except the Scalia seat, you've had this the same party control both. That's just the way that these things tend to go. I think it's a safe bet that Democratic-controlled Senate would not confirm any appointee, any nominee by that Republican president in the first year. I think it's a much less safe bet if you flip it. I think that Republicans would be much more likely to confirm. And I say that not because it means they're like better in some way. I'm not saying that. I think Democrats will have the fury still from 2016, 2017, say payback time. I think Senate Republicans are somewhat more mixed ideologically. A lot depends. Are we talking about 55-45? We're talking, 51-49. But I don't think that. let's just say the people who are making the argument in 2016 aren't going to be making it again. I mean, that was an argument concocted for that particular time. It's not an argument that they could have seriously believed, and there's no reason for them to be resurrecting it if you have certainly if you have a Republican president and a Democratic Senate. I mean, it's not a serious constitutional argument. It's a serious political argument, and you're raising important political concerns. How is this nation going to function if we have a standoff on important judicial nominations? In some circumstances, it could be a real problem. I will say that I think politics shapes and controls and conditions this, and that politics, especially given the media bullhorn, gives a huge advantage to Democrats on this. I'll say further that if Barack Obama had been savvier in 2016, he would not have waited a month to nominate Merrick Garland. He would have done that. He would have made his pick within a week before the Republican opposition had really coalesced. I think things might have been very different had he acted more quickly. Yes.
You mentioned possible legislative options for the conservative legal movement, and I just want to understand what you mean by that. Would you mean either a bunch of Republicans get together and say, look, we think the Commerce Power is way too broad, post-New Deal decisions, we're just going to have this movement where we're just going to pare down all of these statutes that go beyond what we think the proper understanding of the Commerce Power is, and they just do that without regard to content? Or is it more like we need to reduce entitlements or something like that?
All of the above. I mean, all I'm saying is that what we call the conservative legal movement has been focused almost exclusively on judges, and we're talking about judges almost exclusively, or at least predominantly, on the Supreme Court. That makes sense in one very large respect. But especially now going forward, where the courts are not going to be an obstacle to legislative initiatives, I think it's important that conservatives focus their effort on drafting good laws that will withstand legal scrutiny on a whole host of issues. You can talk about entitlements, you can talk about environmental law, talk about abortion. I mean, if conservatives are going to, there's a real danger that they're going to, fritter away or lose the big victory that Dobbs gave them by not being ready to legislate intelligently on the matter of abortion. When I say intelligently, I mean, first of all, laws need to be drafted well to avoid the claims, often in bad faith, but nonetheless claims that should easily be able to defeat about, this somehow would prevent emergency care. But there are conservatives, pro-lifers, I identify myself as one, also need to recognize that you need to persuade, you need to work to persuade, and we haven't been able to persuade people to your view. You need to be ready to take a partway measure and work for more later on. There's no virtue in a massive defeat, and I think for various reasons we can get into the pro-life movement has not been able to do that, and it's taken the pounding so far. Yes.
I was wondering if you could speak a little to the tension between sort of conservative political ends and conservative judicial means. You talked a little bit about how part of the rise and the triumph of the conservative movement is that there were judges with a very coherent philosophy, be that textualism, originalism. And at the same time, you talked about how Dobbs is a victory for the conservative movement. Dobbs, because it overturns Roe v. Wade. But I think there's a very valid criticism of Justice Alito in the Dobbs decision, in that while he does discuss history to a great degree, it's not really an originalist or textualist decision. It's a warmed-over Glucksberg test. It's about substantive due process. And so maybe there's an inconsistency within getting a conservative political end without necessarily having applied a conservative judicial means to get there. And so I guess the real question for me is it a triumph of the conservative movement if you're getting, and maybe you reject the premise, but is it a triumph of the conservative movement if you're getting political ends that are conservative and that are amenable to the right, but the means with which you get there are not necessarily conservative judicial means?
A very interesting question. I will contest some of your premises, but let me try to answer it nonetheless. First of all, have in mind that that Dobbs restored abortion policy to the democratic processes. Dobbs did not dictate a conservative political end. Yes, most of the conservatives wanted abortion policy returned to the democratic processes, but there are plenty of those who say, no, constitutional personhood, this is what the court should have done. That would be, the dictating conservative political ends. Doesn't speak to whether it be justified or not. I'm just saying that would be the, I think, more neatly fit the label of conservative political ends. I reject the criticism of Justice Alito's opinion. Look, one of the challenges of originalism is operating within a system of precedent, much of which is non-originalist, and one has to navigate that precedent. It's one thing to be a law professor, writing in an area. It's quite another thing to be a judge. And there's room there to then say, well, that's a real flaw of originalism, and it certainly is a challenge. But I think Alito reached the right originalist result. He had to keep his coalition together. So while some might say, oh, he should have just thrown out substantive due process altogether, you don't get a majority opinion by doing that. Maybe that's an unsatisfactory answer for you, but I would say that rather than making that an unprincipled opinion, it's one that I think deals with the challenges of applying originalism in a system of non-originalist precedent. More questions? We have a few more minutes, so let me toss out something for you. Then I've been running a Substack newsletter called Confirmation Tales. I don't know, have any of you run across it? Encourage you to take a look. I've been trying to sort of tell the history of the judicial confirmation process over the last 30 years, in part through a series of anecdotes. I start with the Ruth Bader Ginsburg confirmation hearing, my time with Senator Hatch. I'm still stuck back in the 1990s now, but we'll soon get to more interesting times. But again, I think what you see over that over the trajectory of this period is a shift from an attitude of deference on the part of senators who are really afraid to stand up and fight for conservative judicial philosophy to a willingness to engage. And that's actually, I think, maybe most stark on the matter of Roe versus Wade. No one wanted to talk about Roe versus Wade in the early 90s. This was thought to be a huge loser for conservatives. And the idea that you'd be able to get confirmed, say someone like Amy Coney Barrett, whose legal principles predictably indicated that she would view Roe as a legal abomination, and whose own policy views are quite clearly pro-life. And that would simply not have been imaginable. And so part I'm trying to explain how things have changed to make that possible. And as I indicated in my talk here, some of that involves some conservatives standing up at the right time, making smart strategic steps. Some of that involves some pretty bad strategic steps by Democrats. But this whole thing is very much up for grabs, and who knows where we'll be 10 or 20 years from now. So I invite one last chance for anyone who has a question. Yes, sir.
So given the Students for Fair Admissions cases that came out this year, and I know you briefly mentioned it in the employment context, how do you see that being applied there or maybe to other areas of daily life?
Well, okay, so let's take the principle that I think is pretty clear from the SFFA cases, which is the government cannot discriminate on the basis of race, in, except maybe in really compelling circumstances. Is that a fair statement of it? This was applied in the Harvard case only in the Title VI context, with the theory that Title VI incorporates whatever the Equal Protection Clause means, and then applied directly to state universities like UNC in that case. So first is a question of how broadly does this ruling apply to universities, whether public universities like UVA or universities that receive federal funding, which is almost all of them, all but a handful. And I think the answer to that is it's quite clear that it does apply to virtually everything a university does, because that's how Title VI is written and has been interpreted. That is, the particular context of the ruling was admissions programs, but every program of a university, every part of a university is subject to Title VI, as well as the Equal Protection Clause. With an exception, there's actually, I hadn't realized, there's an exception for faculty hiring, which I think is generally going to be subject to other statutory and constitutional, other statutory prohibitions. So there's a Title VI exception. Obviously, there can't be an equal protection exception there. So then you have the question of other bans on discrimination, such as under Title VII, the ban on discrimination in employment, which has been widely read, I think in light of Bakke and Grutter, through some not very careful analytical process, to allow racial preferences in hiring. And I don't see how that principle can stand under the SFA cases. It's going to take some litigation to establish it, but I think you're going to find that employers who racially discriminate, through affirmative action programs, are going to face lawsuits. You've already seen this with the fellow behind the SFFA cases, Edward Blum, I'm not sure I pronounced his name, Bloom, I think, bringing a lawsuit against two law firms that had programs designed only for minorities. The law firms initially said they're going to fight this vigorously, and then they looked more closely, and they have changed their programs. They've recognized that they don't have a legal leg to stand on. So I think you'll see more and more of that. Now, a lot is going to depend. I mean, look, we are a wonderfully, multiracial, multi-ethnic society, and we're going to become even more so in the coming decades. I mean, how one identifies by race, I think for a lot of people it's going to get very, very complicated. Now, of course, you can, one answer to that is you identify by whatever race gives you the most advantage in the process, and it's an understandable approach. I'm not going to fault anyone for trying to game things like that. But I do think that I'm hopeful. We'll see. I'm hopeful that this ruling will pave the way for a much better future in which people are judged much more on their qualities and their achievements than on their race. Okay, thank you all.